Test, test.
You need to test the microphone?
No, I just did. I heard it.
Yeah, man, I'm actually kind of tired today too. Very much prefer not to do this actually.
I was just fried. From the Federalist Papers, you don't command the sword of the government. Marshall doesn't want that. He doesn't want to look weak. But if he says, well, we know that we can't make the executive do anything, so we're gonna say that Marbury doesn't really have a rightful claim to that commission. That doesn't look good either, because I'm sorry, Marbury. Marshall thinks that Marbury really does have a rightful claim. He did get nominated. He was confirmed by the Senate. It doesn't matter if Tom Jefferson or James Madison doesn't like Marbury. He ought to be, he has a rightful claim to that commission. So he doesn't want to look like the executive branch can force the court to make BS arguments that it really doesn't believe. So Marshall's in a pickle here. If he confronts the executive branch either directly or indirectly, the court loses. The court as an institution ends up looking really weak relative to the executive branch. And this is when Marshall decides to do something that has truly baffled Supreme Court critics, scholars for over 2 centuries. Right? The whole fight is between the judicial branch and the executive branch, judicial and executive, judicial and executive. And out of the blue, Marshall turns to the legislative branch in his opinion. And he says, what is it that Marbury's asking? A writ of mandamus. He wants us on the court, the Supreme Court, to issue a writ of mandamus. Where did this power of a writ of mandamus come? Does the Constitution grant to us, the court, the power to issue writs of mandamus? No, it does not. So where would we get the power to issue a writ of mandamus? Why, we would get that power from the Judiciary Act of 1789, which grants to us on the court this power as part of our original jurisdiction. But Marshall's going to say, Congress, the legislative branch, has no power, no authority to add powers to the judiciary. Congress, the lawmaking branch, has only the powers the Constitution grants to it. And nowhere does the Constitution grant to Congress the power to add to the original jurisdiction of the Supreme Court. If you have a copy of your Constitution with you, remember it's in the back of your Federalist Papers. Some of you, I'm guessing, are nerdy enough to carry around some pocket versions or pull it up on your screen. Does Jeff Jensen have a pocket version? Dave's got a pocket version of them right here. Yeah. Okay.
Yeah, Jeff does.
Jeff, I figured he does. Okay. Take a look at Article 3, Section 2. Article 3, of course, is the article that creates the judicial branch. Section 2, the second paragraph. You ready? What this paragraph is going to do, it's going to create the 2 kinds of jurisdiction of the Supreme Court, original and appellate. Quote, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. Original jurisdiction means, jurisdiction is just a fancy word for power. And original jurisdiction means original power over those cases, that those kinds of legal disputes can be brought to the Supreme Court to be heard for the very first time. The original jurisdiction of the case can be right there in the Supreme Court. Let's say, you know, like the case with states. Let's say two states are suing each other over water rights or mineral rights. That sort of thing happens very often. Well, clearly, right, if I don't know, Colorado and Kansas or Colorado and Utah have a dispute over water rights, right? Nobody from Utah wants that case to be heard in Colorado. Nobody from Colorado wants the case to be heard in Utah. They're going to go to a sort of neutral arbitrator, the United States Supreme Court. That case can be heard for the very first time as part of the court's original jurisdiction. And notice there's a period after it. There's the court's original jurisdiction. Cases affecting ambassadors, public ministers, and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction, period. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as Congress shall make. What's appellate jurisdiction? Appellate means to be appealed. It means a case that was already heard in a lower court somewhere else can be appealed up. The loser can appeal the conclusion, the opinion, the outcome. The loser can appeal it to a higher court, to the Supreme Court. So the Supreme Court has appellate jurisdiction, meaning the power to hear cases that have been heard somewhere else. In all other cases, with, where did I lost my page here? With such exceptions and under such regulations as Congress shall make. Congress, in other words, has the power. Let's see here, where can I do this? The Supreme Court has two forms of jurisdiction. The Supreme Court has original jurisdiction and it has appellate jurisdiction. Congress has the power, yes, it does have the power to alter the appellate jurisdiction. It can make exceptions, it can take cases out. By the way, some of you out there think that the Supreme Court cannot be trusted with certain topics. One thing Congress can do, it can accept away, it can take away certain cases and say, you, the Supreme Court, may not. You have no appellate jurisdiction over this category or this class of cases. But the point for our purpose here is that Congress can in fact alter the appellate jurisdiction of the court. However, the appellate jurisdiction. Congress has no power to alter the original jurisdiction, right? That power, what's the original jurisdiction? One more time, real quick. It is the power to hear cases affecting ambassadors, public ministers, and consuls, and those in which a state shall be a party. That's the original power of the court, period. It doesn't say anything about writs of mandamus. You with me? The Constitution's definition of the original jurisdiction says nothing about issuing a writ of mandamus. This is something that Congress added to the court. Now, here's what's curious, right? Yes, Congress has altered somehow the tools available to the court by granting to the court this additional tool, the tool of a writ of mandamus. And the court's basically saying, yeah, well, thank you, but no thank you. You don't have the power to give us that. You don't have the constitutional authority to add tools to our toolbox. The tools we have in our toolbox in our original jurisdiction are only the tools the Constitution grants to us. It does not, the Constitution does not grant you power to add tools to our toolbox. And Chief Justice Marshall strikes down the Judiciary Act of 1789 as an exercise of power that was unconstitutional, that the Constitution never granted to Congress. In this one stroke, this is why scholars, academics who study this stuff, this is why they're sort of fascinated with it. The political maneuvering here is quite brilliant, because if Marshall, as Chief Justice, confronted the executive branch in any way, he was going to lose. The court was going to end up looking weak and impotent. And instead, the court ends up looking mighty powerful as having the authority to declare a law to be unconstitutional and therefore ineffective, having no power, having no effect. He ends up elevating the power of the court relative to the legislative branch, rather than seeing the power of the court diminished relative to the executive branch. By the way, I should have mentioned this before we even got started. If you have a question, I'll take questions at the very end. And to sort of keep alive here our spirit of Vino and Veritas, if you have a question before I get to the end, raise your hand, but don't do it physically. Like, don't actually raise your hand. On the Zoom screen, I believe, Dave, is this correct? There's like a button that, does it say raise your hand? Click that button and Dave will see it. And then what he'll do is he'll unmute you so that I can hear you and you can ask the question. I'm going to take a drink of water and then we're going to read a little bit from Chief Justice Marshall. I hope these political machinations make a little bit of sense. What I have here in my hands, this is actually not William Marbury's commission. This is Chief Justice John Marshall's opinion in the case of Marbury versus Madison, his majority opinion. And what I did is I edited it down for you because I love you. I don't want to give you this big sprawling opinion to what I think are the pivotal moving parts of his opinion. So right there on page 1, third paragraph on the left-hand side, he writes, "It is the essential criterion of appellate jurisdiction," right? Appellate, meaning it's heard somewhere else and being appealed to the court. It's the essential criterion of appellate jurisdiction that it revises and corrects the proceedings in a cause already instituted and does not create the cause. Although therefore a mandamus may be directed to courts, we could be given the power of issuing writs of mandamus. Yet to issue such a writ to an officer for the delivery of a paper is in effect the same as to sustain an original action for that paper, and therefore seems not to belong to appellate, but to our original jurisdiction. Neither is it necessary in such a case as this to enable the court to exercise its appellate jurisdiction. There was no appeal. There had been no court decision by any lower court. There was no appeal involved here. So when Marbury files the motion in the Supreme Court asking the court to issue a writ of mandamus, that was creating an original action, the very first legal action, which is part of the original jurisdiction. He goes on the next paragraph. The authority, therefore, given to the Supreme Court by that act, the Judiciary Act, establishing the judicial courts of the United States to issue writs of mandamus to public officers, appears not to be warranted by the Constitution. And it becomes necessary to inquire whether a jurisdiction so conferred can be exercised. So the rest here is basically his argument as to what the court should do when it comes into a case like this, where Congress appears to have exercised a power that the Constitution didn't grant to Congress. What should the court do? The court has never found itself in this position before. This is also another reason for Congress to not pass many laws. If it doesn't pass many laws, the chances are lower that it's going to pass laws it's not supposed to be passing. This problem he describes becomes amplified, ramped up in the 20th century because Congress is going to become so much more active in doing all kinds of things it shouldn't do. Look on, this is still on page 1 on the right-hand column. The original and supreme will, he means the original supreme will of the people, organizes the government and assigns to different departments their respective powers. It may either stop here, meaning the people. The people may either stop there or establish certain limits not to be transcended by those departments. The government of the United States is of the latter description, meaning we, the people, did establish limits. The powers of the legislature are defined and limited, and that those limits may not be mistaken or forgotten, the Constitution is written. To what purposes are powers limited, and to what purpose is that limitation committed to writing if these limits may at any time be passed by those intended to be restrained? It's a great point, right? Why put down in writing Congress may only do this and may not cross this line? Why put a limit there if they're going to cross the line and everyone's just going to ignore it? The distinction. Oh, this is one of these lessons here. I wish we could teach this to members of Congress right now. The distinction between a government with limited versus unlimited powers is abolished if those limits do not confine the persons on whom they are imposed, and if acts prohibited and acts allowed are of equal obligation. Notice here, the whole premise, the whole rhetorical framework here, who is it that's doing the allowing and the prohibiting? We, the people. This is the right way to think about it. We, the people, allow our Congress to do certain things, and we, the people, have prohibit them from doing certain things. The only question, the important political question, isn't what we are allowed to do or it's what we allow those in government to do. We're the authority, we're the principals, we're the sovereigns. It is a proposition too plain to be contested that the Constitution controls any legislative act repugnant to it, or that the legislature may alter the Constitution by an ordinary act. Between these alternatives, there's no middle ground, right? Here are two options. Either the Constitution controls all legislation, right? And if legislation comes up that the Constitution never authorized, then the Constitution controls it and that legislation means nothing. That's one alternative. The other alternative is that the legislature may change the Constitution by simple statutory law, just passing laws. Right? If the Constitution says we do not give Congress the power to legislate healthcare, and then Congress just goes and legislates healthcare, passes, the Affordable Care Act, and we let that stand. What has Congress basically just done? It's just changed the amount of power that Congress has by just exercising it if you let that stuff go on. So Marshall rightly says here, between those alternatives, there is no middle ground. The Constitution is either a superior paramount law, unchangeable by ordinary means, or it's on a level with ordinary legislative acts. And like other acts, it is alterable when the legislature shall please to alter it. He says in the next paragraph, if the former is true, that is, if the Constitution is a superior paramount law and the Constitution controls what the legislature may do, if that's true, then a legislative act contrary to the Constitution is not law. If the latter is true, if the Constitution has no more authority than just ordinary acts of legislation, then written constitutions are absurd attempts on the part of the people to limit a power in its own nature illimitable. Right? If you're going to pass a constitution, ratify a constitution, and say this constitution has really strict limits on what the Congress may and may not do. And then you just allow those in Congress to do whatever they want to do, to just pass laws over whatever they want to pass, and you let that stand. Then the whole idea of having the Constitution, that's just absurd. That's just stupid. Why did you even waste your time ratifying that Constitution? Jump over to page 2 here. We'll read just a few more lines from Marshall. Left-hand column, top of page 2. If an act of the legislature repugnant to the Constitution is void, does it, notwithstanding its invalidity, bind the courts and oblige them to give it effect? Or in other words, though it not be law, does it constitute a rule as operative as if it was law? Here's what he's setting up. We have a Constitution. Suppose that Congress passes a law that is repugnant to the Constitution. Suppose Congress exercises a power that they were not granted by the Constitution. So that law is repugnant, that law is void, and then it's not a law. It's not a law, and a case comes to the court involving that thing that was passed by Congress. What does the court do in that situation? When the case before it, the facts involved are connected to laws that have been passed that are repugnant to the Constitution. This would be to overthrow, in fact, what was established in theory and would seem at first an absurdity too gross to be insisted on, right? So it would be absurd to say that the court should rule according to, uphold this law that's not actually a law because it's repugnant to the Constitution. And this next phrase, I want to emphasize this very next line, because this is one of the most widely quoted lines in the history of Supreme Court jurisprudence by progressive advocates of a living constitution. The whole doctrine of a living or evolving constitution, they love this line. Woodrow Wilson quoted this line. Scholars in the most prestigious law schools quote this line, and every time they do, they get it wrong. Here's the line that they quote. Quote, this is Marshall. It is emphatically the province and duty of the judicial department to say what the law is. That's true. They are supposed to say what the law is, including when they see a law, they read it. Here's what this law says, and here's our Constitution. And our Constitution doesn't grant Congress any power to pass that kind of law. It's the duty of the court to say that, to say the Constitution did not authorize Congress to pass this. That's what Marshall means right there. But that's not how progressive jurists or progressive scholars or progressive legal minds, that's not how they read that. You know how they read that? When they read, it is emphatically the province and duty of the judicial department to say what the law is, what they mean is the laws, including the Constitution, mean whatever the judicial department, whatever the Supreme Court says that it means. And you see how that one little twist in the meaning of that sentence opens the door to this whole view that the Constitution does not have a fixed objective meaning. Its meaning is fluid. Its meaning changes, it evolves, and it's up to the Supreme Court to tell us what the Constitution means at any given point in time. But look at where he goes in the very next paragraph. It's clear what he means. So if a law be in opposition to the Constitution, you can use the Judiciary Act here of 1789 if you want to. You can think of a more recent example like the Affordable Care Act. If a law is in opposition to the Constitution, and if both the law and the Constitution apply to a particular case, right? If a case comes before the court and the facts in the case involve both this law and the Constitution, so that the court must either decide that the case conformably to the law and disregard the Constitution, or conformable to the Constitution and disregard the law, the court must determine which of these conflicting rules governs the case. This is the essence of the judicial duty. And what he's going to go on and argue is that what the court should do is uphold the Constitution and disregard a law that is repugnant to, that violates the Constitution. Okay, I'll take it. I gotta grab a drink anyway. We have a question.
So it sounds like you're in the middle of answering it anyway, but I was wondering if you thought that John Roberts did basically the same thing, where he passed Obamacare as a tax, knowing full well that it was going to go into effect no matter what the Supreme Court did. So he kept the Supreme Court on the winning side of history, so to speak.
Wait, Terry, say that again. I'm not quite sure how you're characterizing Roberts.
Well, the Supreme Court, with the Obamacare decision, decided that they were going to pass it as a tax.
Right.
And by doing that, it allowed it to go through, even though it really shouldn't have. That being forced to buy insurance, that step of it.
I would argue that Chief Justice John Roberts utterly failed to exercise the duty that John Marshall is describing here. John Marshall's point is, if you have a case that comes before you in the highest court, and the facts of the case involve both the Constitution and a law that was passed repugnant to the Constitution, the duty of the court is to uphold the Constitution and disregard the law, because it's actually not a law.
Yeah, no, I would agree. But do you think it was done in order to maintain the Supreme Court's supremacy, knowing that it was going to go forward anyway?
Well, I mean, by that time it had already been passed.
Right.
I mean, it's sort of an interesting question when you think of within the national government, the three branches and how they relate and power struggles between them. In the case of Marbury versus Madison, Marshall made a decision, and I think even if you disagree with his constitutional reasoning, politically, from a strategic point of view, it certainly did elevate the authority of the court in the minds of citizens to see the Supreme Court striking down, declaring to be invalid a law that had been passed by Congress. What if the John Roberts Court had done the same thing to Obamacare, to the Affordable Care Act, and had said, look, this law, it controls insurance companies. It basically takes control of an entire industry. The Constitution doesn't authorize that. There is no constitutional delegation of power to Congress to pass that, and simply struck down the entire thing. That would, I would argue, that would have bolstered the power, the influence of the Supreme Court as an institution strategically. I think Roberts and the others on the court they're terrified to do that. They were simply too scared to do that. They thought, oh my God, there's so many people who actually want this law. They might start pushing back, and there might be, riots on the streets or things like this, and we don't want to be responsible for that. And so he writes one of the, most embarrassing. The court has written a lot. I was going to say one of the most embarrassing opinions, but the court has produced so many. I don't know where it ranks in the hierarchy of embarrassing opinions. Did I answer your question?
Yeah, no, thanks. I was just curious your thoughts on behind that, and it does. I agree. Thank you.
Okay.
So I'm actually curious though.
Yeah.
Because
Can they hear you?
Can you guys hear me? Yes, everybody's nodding. Yes.
Okay. All right.
You're hearing me over his microphone.
Okay.
So, you talked about with John Marshall that Jefferson could have just said no, right? Jefferson could have just said no. I'm not James Madison. I'm not giving you that commission.
Yes.
Could Obama have done? I mean, because it's the opposite, right? In one case, they're saying no. In the other case, Obama wanted something to go forward.
Yes.
Could Obama, as an executive, said, I don't care what the Supreme Court says. We're going to move forward with this because this is what's right.
You could have. Yeah, you're right. So here, right, in Marbury, Jefferson, his administration, they have something that someone else is saying, you got to give it to us. And they're saying, no, we won't, right? We're going to hold on to it. How do you physically make them turn over something? In the case of Obamacare, right, they're doing it. They're already rolling it out, and they've got their, they have an entire executive agency, not just an agency, a department, Health and Human Services, that Congress has created, which in itself is unconstitutional, right? There's no constitutional authority to have a Department of Health and Human Services, but Congress went and created that thing. They're rolling out Obamacare, and then the court would say, that's unconstitutional. You don't have constitutional authority to do that. Could the Obama administration have continued to just implement it anyway? Yeah, they could have. They absolutely could have. And what you have then is a constitutional crisis. You have, and sometimes it's useful to spark a constitutional crisis because it gets people thinking, what does our Constitution mean? That would be a moment. I'm going to use a phrase here. I wrote about this idea 25 years ago, and I haven't written or talked about it really much since, but I'm going to mention it here. It's this idea of judicial statesmanship. We don't usually think of members of the judiciary as statesmen. We tend to think of, elected officials, policymakers, presidents, those types. But in that case, had the court struck down Obamacare and then had President Obama continue to implement it, what an opportunity there for the Chief Justice of the Supreme Court to stand up, to go on television, to talk to his fellow citizens and remind them what the Constitution means. There's nothing that prohibits a Chief Justice of the Supreme Court from offering some civic education to his fellow citizens and show them, here are the few powers that the Constitution grants to Congress. Nowhere does it grant this power to pass this sprawling, gigantic, 2,500-page bill that regulates the entire healthcare industry. That's why it's unconstitutional. And repeat that over and over and over so that citizens are watching this saying, wow, I got to think about this. There are competing claims here. The court is saying that's unconstitutional, what they're doing, and yet the Obama administration is continuing to advance that. That's some high level, that's very high level, serious politics there. But it would put a spotlight on the Constitution, right? All of that would revolve around the question, what does the Constitution mean? Instead, John Roberts writes this opinion where he says, a tax can be a fee, and a fee can be a tax, and it's so weaselly. And Roberts, by the way, don't forget this. John Roberts, I'm sure he's a very nice man. I don't mean to say anything personal against him. And he had the Affordable Care Act right in front of him, not once but twice. And in both of those cases, he could not find a serious fundamental constitutional flaw. If I was on the Supreme Court, I would find a very serious fundamental flaw to strike down the entire law, not just some little piece or some little detail.
Well, that goes to your Facebook post the other day about courage.
Courage,
right?
Courage.
Did John Roberts have the courage to engage in this, to
right,
create a constitutional crisis?
Right.
And
then follow up, right? Offer some constitutional instruction and inspiration and see where that goes for the sake of saving the Constitution, rather than saying, man, that's likely to spark a big fight and we don't want to be part of that.
But if he didn't, you could make the argument that he had the same motivation as John Marshall. I don't have the courage to stand up and do this, so therefore I don't want, and I think that was Terry's point.
Yeah.
Was I don't have the courage to follow through on that. And if that's the case, I don't want the judiciary to look weak.
Right. I think that's right. Yeah, absolutely. So, let's just wrap up here. He says, this is on the bottom of page 2, left-hand column, very last paragraph there. This doctrine would subvert the very foundation of all written constitutions. It would declare that an act which, according to the principles and theory of our government, is entirely void, is yet in practice entirely obligatory. It would declare that if the legislature shall do what it's expressly forbidden from doing, such an act is in reality effectual. I mean, that was Obamacare, right? Congress did something it is forbidden from doing, and yet we treat it as effective, binding. It would be giving to the legislature a practical and real omnipotence with the same breath which professes to restrict their powers within narrow limits. It is prescribing limits and declaring that those limits may be passed at pleasure. It's a beautiful line, isn't it? If the court allows an unconstitutional law to stand, if they give effect to, if they let an unconstitutional law be binding in a case, then it is prescribing limits in the Constitution and then declaring that those limits may be passed at pleasure whenever Congress wants to do it. He wraps up the very last paragraph here. He says, thus, the phraseology of the Constitution and confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument, by the Constitution. Declare the thing to be void. Do not decide the case at hand based on some unconstitutional law that is repugnant. Any questions here on Marbury versus Madison? Some of you might want to ask, so did Marbury ever get his commission? And the answer is no. Poor crony Marbury did not get his commission, because Marshall's whole opinion is that while he has a right to it, he should. The tool he's relying upon is unconstitutional. So we, the court, we are not going to command. We're not going to issue a writ of mandamus to James Madison, and Marbury's just out of luck. Unless he's going to, I don't know, break into the Secretary of State's office and steal it or something. There's no way legally to go get that mandamus. Anybody have a digital hand raised, or shall we proceed to one of the most counterintuitive ideas in all of the Federalist Papers?
Jeff's raising his hand in real life. Does that mean you have a question, Jeff? I'll have to unmute him. Jeff, go ahead.
So in reality today, Tom, we have all over social media this drama about constitutionality of what's happening in our country, in our states, in our towns. A lot of authority is being assumed, and it seems that every argument about the Constitution is being completely ignored. How do we get out of this, in your opinion?
Well, I don't know that I have a good answer, or an answer that will satisfy you. Part of providing an answer is to sort of point to where we've been and how we got here. I will say this about early American politics. For the first, I don't know, roughly 150 years, roughly, from the time of the founding Declaration and the Constitution, certainly all the way through the 19th century into the 20th century. For that big span of time, I don't want to overstate things here. I want to be accurate. Almost all big national political controversies revolved around the Constitution, disputes around the Constitution. Go back to right in Washington's administration, the fights over whether to charter a bank. Hamilton wanted to charter a national bank. Jefferson pushed back and did not want to, right? And that fight was a constitutional fight. The whole question was it really boiled down to the necessary and proper clause. In fact, it just boiled down to the word necessary. Both Hamilton and Jefferson are writing these essays on what the word necessary means in the Constitution. my point is it focused the attention of citizens on their Constitution. Fights over the Alien and Sedition Acts a decade later, then fights over tariffs in the 1820s, fights over the Missouri Compromise, then the bigger fight over slavery out in the territory. All those disputes were presented as constitutional disputes. They were disputes within the framework of the Constitution. Partisans on all sides were making constitutional arguments to support their positions. And I'm not saying that they were all correct. I'm just saying that what that did to the mind of citizens is it focused the attention on their Constitution, right? One person would say, well, you know, the territory clause, for example, in Article 4, it means X, and then the opposite side said, no, the territory clause means Y. And hearing these things, right, helps citizens to think about what their Constitution means. And in the end, that's what matters. That's what matters the most. Not what the court thinks about our Constitution, and not what Congress thinks about it, not what the president thinks. What matters in a decisive respect is what we, the people, say our Constitution means or doesn't mean.
Which is why this was written. Which is why this was written. It, you know, to have the people understand what this was about.
Yeah, I agree with you. And as you get into the 20th century and where we are today, the Constitution for big political confrontations has largely been eclipsed by cults of personality, right? The personality of politicians, by appeals to, you know, compassion and caring and sympathy and things like this. In fact, I wrote a piece, I haven't seen this, I don't even know if it still exists on the internet, when George W. Bush first ran. That was in, was that 2000? Man, I'm getting old. That was 20 years ago. When he first ran, so here's George W. Bush and his original platform, his first campaign. There were the 4 C's that he would talk about in his big speeches. Compassion, remember he had his whole compassionate conservatism. He talked about compassion, civility, character. Oh, and there's one more. I forget what the 4 C is. But I wrote a piece for the Los Angeles Times saying, why doesn't he add a 5th C, the Constitution? Like, let's get back to talking about the Constitution, why it's important, and recovering the authority of the Constitution. It's just not on the radar. Even of people, conservative politicians like George W. Bush, like President Trump. I mean, that's just not a big central theme, right? I mean, Trump will talk on and on and on about whether to build a wall or not build a wall, or whether to you know, have tariffs and what he calls smart trade policies with other nations, but not the Constitution. And so one of the things I think our job here as members of, you know, the Vino and Veritas Society is talking about the Constitution, helping citizens, our fellow citizens, our friends, our family members, realize what's at stake if we lose this thing. This is mighty important because it's a container. It's a what's the word I'm looking for here? It's a vessel into which we put the power of government, and we say it's going to be limited, and that's hugely important because government is the most dangerous human institution ever created. It's awesome. It can be terrible. We don't want to abandon this tremendous limit on the power of government. So I see it as part of our purpose in what we're doing right here. We need to get better at understanding why this thing is important so that we can, I'm hanging out with Dave Rich a lot, so I'm starting to think like a marketing person, but we need to be able to market the Constitution, brand the Constitution, right? Think of, I'm spitballing here. This wasn't part of my planned discussion, but as I'm thinking, if we did a branding exercise for the Constitution, wouldn't it be kind of interesting to go ask Americans, when you think of the Constitution, what comes to your mind? And I bet for a whole lot of Americans, either nothing comes to their mind or it's something negative. It's something bad, you know, racism or slavery or something like that. We got to get better at branding the Constitution as this thing that is useful for them, that is helpful in citizens doing, you know, living their lives the way that they want to live, getting more of what they want, that it's a good thing, it's a beautiful thing, it's a noble thing, it's something of which to be proud. That's, you know, and how exactly do we make all that happen? Well, we're doing what we can here through Vino and Veritas. And you're going to do more of that, Jeff, when you get elected.
Let's get on to Bill of Rights. 'Cause
Okay.
Your time is
Yes.
much longer on Marbury.
Yes. Yeah, you're absolutely right. Let's move on to number 84 in our Federalist Papers. We're clear at the end here, right? We're at the far end of the book. And when we convene for our final meeting next month, I'll do sort of an overview of the whole book. But tonight, I want to talk about one of the most unusual, counterintuitive arguments. I think, I could be wrong about this, but I think if ordinary Americans know anything about their Constitution, and I'm granting they tend not to know much at all, but if they know anything, they maybe know that there's a Bill of Rights. They've heard of the Bill of Rights. They may not be able to tell you much about what's in it, but they've heard that phrase and they think the Bill of Rights is important for their freedom. And there's a lot of people in the political world who agree with this, including a lot of people among conservatives. They say, "Oh, this is absolutely critical." You know, First Amendment, and think of the cases with our cake baking friend Jack Phillips, right? It's all about the First Amendment right to religious liberty and free speech, and by God, the Second Amendment right to bear arms. That's really important. The authors of the Federalist Papers came out utterly, in principle, opposed to any and all bills of rights. Don't do it. Don't do it. It will be bad for your freedom if you adopt a Bill of Rights. And hopefully many of you right now are thinking, well, wait, what do you mean? How could a Bill of Rights possibly be bad? The Federalist is going to argue that bills of rights are both unnecessary and, even worse, positively dangerous. Let's walk through the argument here and try to understand what they mean. Let's see, I'm in number 84. I am on page 510. This is 1, 2, 3, 4 paragraphs in. Publius first is going to offer a kind of summary of many of the key strategic design features of the Constitution that protect your freedom, that help keep you free. So he says, independent of those which relate to the structure of government, the whole separation of powers, right? The whole fact that we have different powers and different separate branches, and that whole argument back in number 49. Independent of that, he says, look at these following features of this Constitution. Article 1, Section 3, Clause 7, judgment in the cases of impeachment shall not extend further than to removal from office, but the party convicted shall nevertheless be liable to trial, judgment, and punishment according to law. So if those in government try to hurt you, they can be impeached, they can be removed from government, and then second, if they actually violated the law, they can be arrested and charged and put in jail. Section 9 of the same article, Clause 2, the privilege of the writ of habeas corpus shall not be suspended, except in cases of rebellion or invasion. Habeas corpus is, we could do an entire seminar on the history and significance of habeas corpus. The way tyrants, one of the preferred ways that tyrants have of controlling their subjects is that power to simply go show up at their house in the middle of the night and take them, and they're gone, and nobody knows where they went. This is the way of tyrants, and habeas corpus is this tremendous institutional protection against that. we say, you, our government, you may not do that. You do not get to just show up and take someone and no one ever hears from them again. Habeas corpus, right? It's Latin for simply present the body. You arrest someone, you in government, you got to present the body in a public way, in a courtroom where citizens can show up, and you have to explain why you've arrested this person, right? What exactly is going on, what you're charging them with. You don't get to just take people and send them away to some, some gulag or some death camp or things like that. No. Clause 3, no bill of attainder or ex post facto law will be passed, right? You in government, you don't get to pass a law criminalizing today what I did yesterday. You don't get to do that. No title of nobility shall be granted by the United States. No kings, no princes, none of this airy-fairy medieval royalty crap where people have these titles and therefore they get more perks, more power, more privilege than anyone else. No titles of nobility in the United States. Every member of every government, city government, county government, state government, national government, they're citizens and nothing more. Nobody in any government position is anything more than an equal citizen with the rest of us. Article 3, Section 2, Clause 3, the trial of all crimes, except in cases of impeachment, shall be by a jury. So if you're going to charge us with a crime, our fellow citizens get to sit and judge whether or not they think we actually committed these crimes. You can read through the rest of this paragraph on your own. His point is, add all these together. Add these features together, and it's awesome. This is incredible in terms of protecting the liberties, protecting the rights of citizens. Now he turns, this is on page 512, to the topic of an actual Bill of Rights, meaning let's list it off, right? The right to free speech and the right to bear arms and the right to religious liberty, a bill or a list of rights. He points out on the top of page 512, it has been several times truly remarked that bills of rights are, in their origin, stipulations between kings and their subjects. And he's right about this. As a historical matter, this is where bills of rights came. They came from medieval monarchical regimes, where a king claimed authority from God to lord over subjects. They were abridgments of prerogative. The king had the prerogative power. They were limitations on his prerogative power in favor of privilege, reservations of rights not surrendered to the prince. Such was Magna Carta, obtained by the barons, sword in hand, from King John. Notice the authors of the Federalist Papers here are not holding up the Magna Carta as some model for us to follow. Magna Carta was a document suited for kings and subjects, not for equal free citizens. Such was the Petition of Right, attained under Charles I. He gives several examples here, and then he says, Publius says, it is evident, therefore, that according to their primitive signification, I love that word, it's primitive peoples, feudal people, subjects who actually believed that a king was a king. That's where bills of rights came from. According to their primitive signification, bills of rights have no application to constitutions professedly founded upon the power of the people and executed by their immediate representatives and servants. Oh, I love this language, right? Publius is calling every elected member of every level of government is a servant, right? They are our servants. Here, and he means here in the United States, here in strictness, the people surrender nothing. And as they retain everything, they have no need for particular reservations. They don't get a list rights. Right to speak freely, right to take a vacation when I want to, right to hang out with my friend. I don't have to list those rights. Quote, we the people of the United States to secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Quote, he's quoting from the preamble, right? Here, Publius says, is a better recognition of the popular rights than volumes of those aphorisms which make the principal figure in several of our state bills of rights and which would sound much better in a treatise of ethics than in a constitution of government. Bills of rights, the origin was subjects living under a king, medieval kings. And what was the premise? What was the foundation? What was the platform of a medieval king? The idea of the divine right of kings to rule, right? The whole divine right theory of kingship. The divine right theory of kingship said that God appoints and anoints a king. If I'm the king, it's hard to imagine, isn't it? If I'm the king, I'm King Tom. According to the medieval political theory, where did I get my authority to rule you? If I'm the king, and the answer is God. Authority straight down from God to me. That's why I don't need your permission. Why would I need your permission when I just got authorized by God himself to rule you? That's what God told me to do. I have to do it. I don't have a choice. He commanded me to be your earthly Lord, your king. That means I, as king, I have plenary power over everything. Some of you maybe, how much room do I have over here? This is a great word, plenary. Original power, total power. I, as the king, I have plenary power, total power. I don't have some enumerated powers. God authorized me to rule over you, which means I have plenary power over you, total power, original power, unlimited power. And in that circumstance, some of you came and stuck a knife at my neck. This is the way British history unfolded, and said, okay, King Tom, we know you have plenary power. We know God authorized you to do whatever you want. But by golly, we are listing out several things here. A right to free speech, a right to a free press. We don't want you to interfere with that, or we'll slit your throat. And we know you have lots of other powers, but you leave those things alone. And the king said, okay, I agree. I don't want to have my throat slit. That's how bills of rights came to be. But do you understand that premise of the king having total plenary power is important for the Bill of Rights to make sense? The reason you got to list rights is because the government, the king, has the original power to control everything, to regulate everything, to command everything. We, however, we Americans, is that the premise of our government? Do we say in our Constitution that government has plenary power, total original power over everything? No. Who decides what powers our government has and has not? We the people. The premise is totally different here in the United States. We the people are sovereign. We the people have plenary power, sovereign power over everything, including our government. You know what powers our government has? The powers we decide to give it. The powers we enumerate and list off in that Constitution. That's it. And therefore, we don't need to list rights. We simply don't give our government powers to regulate, say, our speech. Think about this. If we grant to our government no power to regulate our speech at all, and our government does not attempt to regulate our speech, what is the result? The result is a bunch of free people speaking freely. See how it works? How is it that people come to speak freely? When their government's not trying to censor or control or regulate their speech. Suppose we, the people, give to our governments no power to regulate our religious worship, the way we worship. No power at all. You don't get to tell us what church we have to go to, or what churches we have to fund, or what churches we have to buy or build, none of those things. And suppose our government in no way regulates our religion at all, zero. What's the result? The result is a bunch of free people worshiping freely. Some people want to go to this church, and so they go to that church. And other people want to go to this other church, and they go to the other church. Some others want to build a new church. They pool their money together, and they build a new church. Some other people back here don't want to go to church at all, so they just don't go to church. Religious liberty happens in the absence of government control. Free speech happens in the absence of government control. Let's read here a little bit more from 84. This is on the top of page 513. This first full paragraph. I go further and affirm that bills of rights in the sense and to the extent in which they are contended for are not only unnecessary in the proposed Constitution, but would be dangerous. They would contain various exceptions to powers which are not granted, and on this very account would afford a colorable pretext to claim more powers than were granted. For why declare that things shall not be done which there's no power to do? Why, for example, should it be said that the liberty of the press shall not be restrained when no power is given by which restrictions may be imposed? I will not contend that such a provision would confer regulating power, but it is evident that it would furnish to men disposed to usurp a plausible pretense for claiming that power. Do you see where he's going with this? If you say government shall not infringe on free press, think of those conniving little shits in Congress who are sitting there looking for any excuse at all to exercise more power over you, including more power over the press. And they'll say, it's said that we're not supposed to exercise control. That must mean the Constitution's worried about us controlling the press. That must mean there is some authority somewhere to control the press. You see how it leads in that opposite direction. Don't list rights for which there is no power to injure. We've granted no power to injure. I had a student once who it was kind of funny. This is probably would violate all kinds of federal laws and regulations today. But she stood up and she said, so if I understand right, this whole argument over a Bill of Rights, it's sort of like this. With no Bill of Rights at all, none. Just the original Constitution where we the people list certain powers of government. That's it, period. It's as if we the people are standing here with a gun to the head of government, those in government. And the burden is on them. Every time they in government want to do something, they got to turn to us and ask us our permission. And so they got to turn and say, oh, we're pretty sure you gave us that power in the Constitution, right? We want to pass this law or do this thing. That's constitutional, isn't it? We're asking your permission. And the people are standing there with the gun to their head, deciding either, yes, we did give you that permission to do that, or no, we didn't do that. But when you adopt a Bill of Rights, now it's government standing there with a gun to the head of citizens. And the citizen says, I would like to speak freely. I'm pretty sure I have the right to free speech, don't I? I'm pretty sure I have the right to bear an arm, don't I? I think I have the right to religious liberty. I think that's in the Bill of Rights, isn't it? And government now is in the position to decide what rights are in that Bill of Rights and what rights are not. When you go to write a Bill of Rights, you can never write a Bill of Rights that's comprehensive, that encompasses every kind of liberty, every kind of freedom, every kind of activity human beings might want to do. You can't. And so a list of freedoms, a list of rights can be used as a limiting tool. All of a sudden, government can look at these rights and say, hey, if it's not in the list, you don't have it. If it's not in the list, you don't have it. And it gets even worse. Even the rights that are in the list, We have rights listed in the Bill of Rights: free speech, religious liberty. Here's a favorite: right to bear arms. That's in there, isn't it? The right to bear arms shall not be infringed. And what does that encourage lawmakers, judges, regulators to do? It encourages them to come and define what that means. And as they define what the right to bear arms mean, they are limiting your freedom to defend yourself. They all of a sudden now they get real interested in what the word bear means. And what did the word arms, what did that mean in 1787 when the Constitution was drafted? This leads to scenes like Dianne Feinstein sitting, there's a video out there somewhere of this. She's sitting on the floor of the well of the United States Senate, and she has these different guns. She holds up one and she says, "No American needs a gun like this. Look at how scary this gun is. The Second Amendment did not include guns. These guns right here didn't even exist when the Second Amendment was written." And she holds up this other gun and says, "This one looks kind of harmless. I think that's included in the Second Amendment." And you have a bunch of judges who want to do the same thing. And they want to do the same thing with the right to free speech. They want to define what free speech includes and what free speech does not include, and what religious liberty includes and what religious liberty doesn't include. So you have the spectacle of this bake shop owner on his hands and knees begging, "Please, please, judge, I'm pretty sure I have religious liberty, and in the name of religious liberty, I just don't want to bake that cake. Please let me not bake. Please give me permission to not bake that cake in the name of my right to religious liberty." And then the judge is sitting there saying, what do you think? Does the right to religious liberty include the freedom to not bake the cake or not? They are deciding what our rights mean. Therefore, Publius's point is, that's a terrible politics. That is not the kind of politics that is going to protect freedom. You never want to be in the position of trying to beg permission to exercise your own rights, to beg some judge or some lawmaker somewhere, some regulator to define your rights in such a way that you can do what you want to do. It's a much better, a much healthier politics to have a constitution that enumerates certain powers. We, the people, we give to government these powers, period. Stop the Constitution right there. And then every political controversy will revolve around one simple question: did we, the people, grant power to government when the thing that government just did? That's the only question ever to ask. This lesson is so simple, and yet the Bill of Rights distracts us. We get sidetracked so easily, and including some smart people. The fellow, I keep forgetting this guy's name. He's popular. He's a very smart guy, constitutional guy. He used to do these kind of funny videos where, this was during the Obama administration, he would pretend like he was Obama giving a speech. He would dress like the president. He'd have the big presidential seal. Which is Bill Whittle. And I was at a meeting with Bill Whittle. I was at a dinner, and Bill Whittle was giving this presentation. And I want to be clear here. Bill Whittle, he's a good guy. He's a smart guy. He is trying to recover the cause of constitutional government. And Bill Whittle said, "Hey, if you members of Congress, if you want to regulate our guns, you first must pass an amendment that repeals the Second Amendment. Repeal the Second Amendment first, and then you are free to regulate our guns." And I jumped up instantly. I said, "No, Bill, you just fell into the trap that Hamilton warns us about. If Congress or the American people, it doesn't matter the formality of it, if the Second Amendment was repealed tonight, just imagine no Second Amendment, it's gone. Does the Constitution grant to Congress any power to regulate our weapons? No, it does not. And that's the important question. The important question is not what the right to bear arms means and what it doesn't mean, and what kind of guns are included, and does it include knives, does it include bazookas? That's the wrong question. The right question is, did we the people grant to Congress power to regulate our weapons? And if the answer is no, we did not grant them any power, then they have no rightful constitutional authority to legislate over those matters. And it doesn't matter what the Second Amendment means. The Second Amendment is irrelevant. Yes, you heard that correctly. Let me repeat it. The Second Amendment is irrelevant for protecting the right to bear arms. In fact, it gets in the way because it encourages judges and lawmakers to define what the right to bear arms means. It would be better if we had no Second Amendment and we simply enforced. We made sure that Congress only exercised the few powers that we granted to it. Now, I'm not suggesting that we go on some campaign to repeal the Bill of Rights. We're not going to repeal it, practically. My point is to help you think like a constitutionalist. It is a mistake. It is a decisive, strategic mistake when we stand on the ground of rights listed in the Bill of Rights. Don't ever do that. Don't stand on the right to free speech. Do not stand on the right to religious liberty. Don't stand on the right to bear arms. Rather, stand on the ground of the few powers we granted to Congress. And when Dianne Feinstein's sitting there going, I think this gun's too scary, and I think this gun looks okay, the thing to say to her is, hey, Dianne Feinstein, who the hell gave you any authority to regulate our weapons? Any. We don't care what you think about these guns. We don't care which ones you think are scary or not scary. Go home and sit and talk about that over dinner with your friends in California. But you don't have any constitutional power to legislate, to regulate these things. And that's why Publius warned against adopting a Bill of Rights. He says, he wraps up, if you look on the next page, this is 514, that bottom paragraph there. There remains but one other view of this matter to conclude the point. The truth is, after all the declamations we've heard, that the Constitution is itself, in every rational sense and to every useful purpose, a Bill of Rights. The Constitution. And this is before the Bill of Rights was added. He's saying the Constitution is a Bill of Rights. It's more effective than any list of rights because what it does is it enumerates and limits the powers of government. And as long as the powers of government are limited, then government cannot censor us. Government cannot control us. Government cannot decide what we are allowed and not allowed to do. It's just the opposite. We, the people, decide what those in government are allowed to do and not to do. We got a Bill of Rights. And I'm noticing the time. It's late. I'm going to summarize here, and then I'll take any questions. Here's how we got a Bill of Rights. There's basically three positions. There's Hamilton. He writes 84. Hamilton is utterly, principally opposed. He says, don't ever adopt a Bill of Rights. The other position, the other extreme is Thomas Jefferson. Jefferson is railing for a Bill of Rights. He's in France, right? He's not there when the Constitutional Convention happens or when the Federalist Papers are being written, but he is corresponding with Madison. And Jefferson is saying, you got to add a Bill of Rights, have to have a Bill of Rights. Jefferson in this moment, I think is thinking poorly. He doesn't think very well about this. He's thinking like a slavish European. He's thinking like some subject under a king. In the middle is Madison. Madison is persuaded by Hamilton. He agrees with Hamilton, no Bill of Rights. And as I mentioned before, Madison gets elected to the first Congress. And he shows up in the first Congress, and what he sees, so the Constitution has been ratified, but many states had made it very apparent, even in their ratification documents, they said, we want a Bill of Rights added. Madison shows up to Congress, and he is surrounded by these critics. They are a minority, but they're a big minority and a loud and influential minority. demanding, clamoring for a Bill of Rights, and he starts seeing their proposals, and their proposals are disastrous. What they are proposing as a Bill of Rights would end up destroying the integrity of the original Constitution. Some of them, for example, would mandate state establishments of churches, all these terrible things. And he's looking at this thinking, holy crap, here we went through that whole convention and we got through, you know, a constitution that's not even perfect, but it's pretty good for the work of a large convention. And now these jokers are going to destroy it by adding what they're calling a Bill of Rights, which is just a bunch of partisan hackery. And so Madison decides to write a Bill of Rights himself. He is the main author of what becomes the Bill of Rights. And his goal is this: to write a Bill of Rights in such a way that is totally redundant, that neither adds nor detracts anything from the original Constitution. And for the most part, he's successful. Think about the very First Amendment. Think about the first line, first sentence of the First Amendment. Congress shall make no law respecting an establishment of religion, right? It's a limitation on Congress. It says Congress may not do something. What may Congress not do? It may not make a law respecting establishment of religion. Did the Constitution anywhere grant Congress the power? In Article 1, Section 8, where it lists the powers of Congress, is there a power to make laws respecting establishments of religion? No. And so the whole framework of the Bill of Rights is basically repeating things that Congress doesn't have the power to do. There could be one in there that says Congress doesn't have the power to make flying pink elephants the national emblem of the United States. And that is true. There is no power in the Constitution for Congress to make flying pink elephants the national, you know, emblem of the United States. This story, by the way, I'm going to step out of the frame just for a moment, if I can hear this. Put my finger on a book. This whole story is beautifully told in. Is that clear, Dave? Can you see that? The title is From Parchment to Power: How James Madison Used the Bill of Rights to Save the Constitution, by Bob Goldwyn. And it's a beautiful little book. And it tells this story that I'm summarizing right now, of how Madison goes from being persuaded by Hamilton that there should be no Bill of Rights to a practical matter. What he realizes is we're going to get a Bill of Rights whether we want it or not. It's going to happen. There's so many people who still think like slavish Europeans. They're going to adopt a Bill of Rights. And if I don't participate in it, it might be a terrible Bill of Rights. And so I might as well get ahead of the curve and actually draft it and try to minimize the damage that's done through the Bill of Rights. You see this especially in the 9th and the 10th Amendments, right? Which say, hey, just because we haven't listed rights here, people still have them. Powers not specifically delegated to the national government are reserved to the states. Although lawmakers, citizens, judges very often forget about the Bill of Rights. Okay, ladies and gentlemen, thank you all very much. Do we have any questions or comments?
No digital hands up yet.
If you have anything to add, press your raise the hand icon.
I got applause.
Thank you. I promise you, this little exercise of thinking through why a Bill of Rights is positively bad for freedom, it'll change the way you think about politics, about policies, about government for the rest of your life. I promise you, you're going to find yourself in these moments where there's some law has been passed, some regulation, something. And people who are your friends, your allies, who care about freedom, they're going to be talking about the First Amendment right to free speech or religious liberty or something like that, right to bear arms. And you're going to remember this, but wait, Cranwitter said Publius said, this is shaky ground to base freedom on a Bill of Rights. What's much more secure is challenge those in government to demonstrate the source of their authority, the source of their constitutional power. That's the real confrontation we want.
With no hands up, I'm going to pose the first question then.
Okay.
We have a small handful of amendments, maybe even only just one or two, like the 16th, that grant Congress additional power. 16th Amendment is an income tax.
Yep.
Right? It granted power
Yep.
to Congress, something it didn't have in the original Constitution.
Yep.
If we didn't have the Bill of Rights, to say, to put it out there, right? Right to bear arms, Second Amendment. Are we more likely to see an amendment passed today, right? You have all these people out there who say, guns are scary, I don't want people to have guns. And you've got a majority who say, no one should have an automatic weapon.
Yeah.
Are we more likely today to see, more people approving an amendment that says Congress now has the right to regulate arms, because it was never talked about, and now we're starting to grant Congress powers?
Yeah, I don't know. So here's an important thing to remember. When the Federalist Papers is railing against bills of rights, and by the way, I'm incredibly sympathetic to the argument. I've used it in my own political thinking. It's why, for those of you who follow what I do, you won't see me hardly ever basing some important argument about something really important upon the right of free, about any right listed in the Bill of Rights.
Not everybody can hear me, so maybe repeat what I was saying. Repeat my question too.
Oh, well, here you repeat it so they can hear you.
They can't hear me at the angle.
Oh, I see. So Dave was asking whether or not if we did not have a Bill of Rights, later amendments start granting more powers to Congress, right? This is the 16th Amendment grants them power to tax our income. The 14th Amendment grants Congress power to oversee what's going on in the states and make sure that states are offering equal protection of the laws and all these things, which opens the floodgates of a regime of affirmative action. Would we be more likely to see amendments being passed if we didn't have that original Bill of Rights? And I'm pointing out that one of the things that Hamilton and Madison could not have foreseen, they could not have foreseen the progressive movement. This whole idea that, right, there are no natural rights, that we want to adopt a living, right? I mean, the whole idea of a living constitution is precisely what John Marshall was railing against, right? He said, look, if you write a constitution, and that written constitution has limits and says government may not go past the limits, it's a limitation on government power. And then if you ignore that, if you let government exercise powers that beyond the limit, then it's absurd, it's ridiculous, that's not actually a constitution. And yet here come these progressives a century later saying, yeah, we should do exactly that. We should reinterpret, right, the Constitution so that where it used to seem to have certain limitations, we're going to reinterpret those same words to allow government to do what it used to not be able to do. Man, once you get into that context, you know, why even amend the Constitution? In fact, I'm looking over here at my bookshelf to see if I can put my finger on where is it? Bruce Ackerman. I can't put my finger right on it. You can look up this fellow. Bruce Ackerman is I don't even know if he's still alive anymore, but he was certainly one of the most distinguished constitutional scholars in the realm of law school intelligentsia, law school academics. He was a professor for a long time at Yale Law School, #1 law school in the country. And what's that?
He's
still alive. And Ackerman's whole thesis, he wrote this big sprawling book titled We the People. And his whole thesis is that he says there are two ways to amend the Constitution. Get this is great. The intellectual imagination knows no limits. There are two ways, he says, of amending the Constitution. One way is following the process in Amendment 5. Or I'm sorry, Article 5. Right. So some of you in this meeting tonight, some of you are familiar with the whole idea, right? An Article 5 Convention of States, and they are to propose amendments formally, constitutionally. There is that process, and he acknowledges it. That exists. He says, but there's a second way to amend the Constitution that's way more useful. It's way more convenient, and that is, we the people, a nation of people, just start to view our Constitution differently, and for all practical matters, it is amended. It means something different. And the example he uses, I mean, this is a powerful example he trots out. The Social Security Act of 1935. He said there is virtually no one, maybe a few cranky, libertarian types or constitutionalists off in some dark corner, but for ordinary American people, they think they have a right to Social Security. All right. In fact, they're angry if they think they might not get their Social Security. Even though, and Bruce Ackerman, to his credit, he acknowledges that Congress had no constitutional power to pass the Social Security Act of 1935. I mean, what is Social Security? Simply a transfer program. It takes money from younger people and transfers it to older people. The idea that people pay in their own money, I mean, that's a complete fraud. Most retirees burn through, they get paid back every penny they ever paid into it very quickly. And then for the rest of their life, if they live another 20 years, they're just being subsidized by the younger generation. It's a transfer, it's a wealth transfer program. And the Constitution does not authorize Congress to do that. So in that sense, Social Security is unconstitutional from a strict constitutional point of view. But Bruce Ackerman says, once the entire nation, citizens and their elected representatives in Congress and their judges on the Supreme Court, and everybody starts to view Social Security as constitutional, then for all practical purposes, it has been amended. Just start viewing things as constitutional, and that's how you amend it. And the danger we're in today is we're in that realm where Congress passes things and we do it, and over time people get used to it, and they either assume it's constitutional or they don't really care if it's constitutional or not.
Interestingly, when you mentioned him, I pulled him up online. He's now writing for Slate magazine, which is a very, very, very progressive.
Yeah, of course.
And he is defending the constitutionality of a lot of the progressive.
Right.
Talking about, he wrote an article, for example, on why Elizabeth Warren's wealth tax is constitutional.
It's constitutional, sure.
So,
Is he still teach at Yale Law School?
No, he's teaching it. He's Sterling Professor of Law and Political Science at Yale.
Yep. That's him.
And most recently wrote a book called Revolutionary Constitutions.
Yeah.
All right. So Susan had a question, but wanted me to just ask it.
Okay.
She wants to know, how about laws that strengthen parental rights? Seems we need protection, but now seems like not such a good idea. And Bethany's saying, can't hear me. So if you can re-ask that.
So the question is about parental rights, laws
that strengthening potential rights. Seems like we need to protect parental rights, but based on your comments about the Bill of Rights, maybe isn't such a good idea. But there are groups out there trying to promote parental rights.
Yeah, I think I would have to know more details here of what's going on. Just keep in mind, the short answer, I don't know enough about the background of the question to give a thoughtful answer. The big general point here is freedom happens naturally in the absence of government control. The only thing that hampers freedom is when government's there, right, with their hands around you. They're controlling, regulating, commanding, confiscating your property. Get rid of that control, right? Say to government, back away, don't do this stuff. You and government, you stay away. Then freedom results naturally. Freedom doesn't require anything. You don't have to do anything positive. You don't have to list any rights. You just got to keep those in government away, and freedom will happen naturally. That's sort of the big lesson here that the Federalist Papers is ending on. No, I mean, this is the second to the last paper, and number 85, the final paper, is sort of a summary. And this is the theme of the second to the last paper. You don't need to do anything for people to live freely. Just stop controlling them. Just stop beating them up. Stop taking their stuff. Stop regulating their businesses and their lives. And freedom will happen very, very naturally. Anyone else? Going once? Going twice? I think our May class, if I recall correctly, is May. Actually, I don't recall. I think I'm confusing it with something else. So without a calendar in front of me, I'm not sure. But we'll be communicating with you guys. We're going to see what's going on. We don't know yet for sure. Would love to be able to meet, together in Fort Collins for our final meeting. I don't know if that's going to be possible or not. So we'll see what's going on. But one way or the other, we will. We'll wrap up the program, and thank you for your patience tonight. I know this isn't what any of us signed up for, sitting in front of a computer, but I'm going to pour myself a little glass of scotch after this. I hope you're doing the same, and I look forward to seeing all of you again soon. Thank you and good night.